have that. So hi everyone. So we have Gene Trowbridge here today. So he's one of the authorities on real estate syndication, actually. So he is an attorney, and he's the author of the book called It's a Whole New Business. And he's a founding partner of Trowbridge Law Group, AOP. So with that, I'm going to pass it on to him, and I really look forward to his lecture, which I'm sure will be really, really good learning for all of us. And especially everybody who is interested in setting up like real estate, private placements, like raising capital with other people, etc. Thanks, Gene.
Okay. Hi. Thanks to everyone. You have me a little bit at a disadvantage. Do you want me to show 4 or 5 slides that lead me through this, or do you just going to ask and talk to me and we'll talk about questions?
We can go with some of the slides and then.
Okay.
Yeah.
You're going to give me a minute here. Let's see what I can do here. Sorry.
No problem. Take your time.
Well, all right. Let's see what we've got. Yeah, this will be a good one. This will be good. Plus, this is fun. Okay, this is fun. All right. So, thanks for having me. Trowbridge Law Group is my current partnership that I have as far as putting together syndications, and this is what we do. You can find me at Gene at Trowbridge Law Group. But I want to talk a little bit about my past. Yes, I'm the founding partner of the law firm, but what's really important is I am a former syndicator. Stefan, I did 16 syndications with about 26 properties, primarily building self-storage facilities and in Southern California, raising some money from the broker-dealer firm. And one day I sat down and I counted how many K1s we had sent out that year, and it was 1,676 K1s. I was representing about 850 investors. And you know what I said to myself? This is crazy. In the old days, and this was in, 99, 2000, 2001, there were no back office companies who helped you with all this back office stuff, which there are now. And so I thought, boy, if I'm going to continue to do this and continue to grow, I think I'm going to rent more space and hire more people, and I didn't want to do that. So I went home for lunch and sat around the kitchen table with my wife, where all the great decisions in life are made. And I said, you know, for the last 15 years of my career, I think I'll go to law school. We had 2 kids in grade school. My wife was working. We sounded like just a stellar idea, didn't it? Law school at night, part-time. And so I've been doing that for 27 years now. So I didn't quit after 15. So I went to law school, and I've done a whole bunch of stuff in my career. My career really has been 3 things: real estate broker, syndicator, securities lawyer. And in the middle, I spent 40 years teaching CCIM courses, if anyone knows what that is. So I've been a lot of time educating people, educational-based marketing, Stefan, like you're doing, training people, and that helps you get to know people. That's exciting. The private placement market that we have is huge. This slide says that in the last 12-month time that the that really isn't right. 2017 isn't really right. It was 12 months in the middle of 18 to 19. The private placement market was $1.8 trillion. That's more money than was raised on Wall Street. And about 90% of this money was raised in Regulation D, Rule 506, which is what all your people need to know about. So this is big. This is big business, and here's how we do our work, Stefan. We have a system where someone comes to us and says they want to be a syndicator. So somewhere along the line, we have to deal with giving them a manager LLC. And what they want to do is they want to syndicate a property. And the property is going to sit in investment LLC. And then they're going to raise money from members. The members are going to put their money in investment LLC. And the manager is going to manage investment LLC. And every once in a while, you have to have a key principal or enhancer to help you with stuff. Now, there's a couple important things on this slide. One of the important things is that this manager is an LLC, and I believe it should have more than one person. Stefan, if you were going to put an offering together and you needed to raise $50,000 from a bunch of people, and I came to you and I said, I've got the $50,000. I'm happy to invest, but tell me, Stefan, what happens if something happens to you? There's a question.
Yeah, that's.
You got an answer?
Part of the job of the SEC attorney to figure out.
Yeah, no. Well, you can't leave your investors in that kind of a predicament. So I always suggest that we have at least two people in the manager LLC, and it's not that you're going to die. I've had people go bankrupt, get divorced, get sued. I had one guy hit his head on a rock skiing and turned out to be a quadriplegic, and he spent a year in traction. Well, who's going to run the fund? All right. And I know these from experience because I've been the person that's brought in to run the fund when there's trouble. So I know that that's a disappointing thing. And another thing that I think is important is just the flow of this. We've got members investing their money in an LLC, probably for profit, right? Why would you do that if you weren't going to make a profit? And someone is managing it. The perfect definition of a security. In a security, the members are passive. The manager runs everything. And what they're trying to do is they're trying to make a profit. So the securities laws came along, and the government said way back in the 1930s, people are raising money for these offerings, and we need to protect the investors. So there were two securities laws that were passed. One securities law said, let's protect the investors from someone giving them fraudulent investments, the paperwork. And then let's protect investors from having fraudulent people sell the paperwork. So the one that we're most interested in is the one that protects people by looking at the paperwork. Because in the securities law, you can sell your own securities. You don't need a license. It's like for sale by owner in real estate. If you issue your own securities, you can sell it without a license because you qualify for the issuer exemption for sale by owner. So what we really need to do is make sure that the paperwork is right. And in the law about the paperwork, the first thing they had to do is they had to define what a security was. And that definition starts with the words a note, a stock, a bond, and then it goes for a couple hundred words. And right in the middle, they threw a term called investment contract, kind of a catch-all. No one knew what that was until about 10 years later. About 10 years later, a lawsuit worked its way all the way up to the Supreme Court. And the issue was that this firm in Florida, the Howie Agricultural Company, was selling small pieces of dirt, maybe quarter acre, half acre pieces of dirt to people, and said, you know, on this dirt that you're buying in our agricultural farm, there's grapefruit trees and lemon trees and orange trees. And you buy the dirt and we're going to manage the trees. We're going to raise the fruit, process the fruit, sell the fruit, share the profits with you, and you can pay for your lot. Everything was on just like a land contract. You can pay for your lot, and eventually your lot will be paid for, and you can continue to make money from this investment. Well, the company went bankrupt. Now all the people had to make these payments on their land contracts, but there was no money coming from the company. So they stopped paying. So the company sued them and said, you got to pay on your land contract. Some attorney said this wasn't a land contract. That wasn't why people bought, so they could buy some dirt with some grapefruit trees on it. They bought because the company said they would harvest and sell and share the profits in the agricultural stuff. And that was decided different ways. So it went all the way to the Supreme Court, and the Supreme Court finally said this is the perfect case, of all things, a real estate case, a perfect case to define an investment contract, an investment of money in a common enterprise with an expectation of profit through the results of the promoter, which was Howie. Okay, so that's what we have. And if I go back here, that's what we have. We have an investment of money in a common enterprise for the profit managed by the promoter. That makes it a security. If we didn't have the promoter, we had an investment of money in an LLC that owned property, and the people that were in there just simply ran it themselves and voted, and everyone had an equal vote. No matter how much they invested, every vote was one. You could probably call that a member managed LLC. But you know, you get too many people, it doesn't work. And you can't have someone, let's say I put up 80% of the money and you put up 20, Stefan. And because I put up 80, I can make all the decisions. Well, then I really am the manager, aren't I? So everyone, in order to make it a member managed LLC and not be a security, I'd have one vote and you'd have one vote, no matter how much I put in. And that's how we would do business. And that would keep us out of the security law. Do you have any questions? Any questions yet from anyone? We've got a lot of people on here.
No, I think this is a very clear, like a very good chart, like a very good presentation actually of what the syndication contains, like the main components.
Well, so we've got Howie, and then here's kind of the flow chart. The flow chart starts with, is it a security? And I can stay out of the security world. I get all sorts of calls. I call them homework calls. People who want to be syndicators, but for some reason, they think they should talk to an SEC attorney. Okay. And so they call me and say, Gene, I want to put together a group. I don't want it to be a syndication, is basically what they say. And I said, well, you know, if you put together a group, it is a syndication. That's what a syndication is. And if you're going to put together a group to buy a piece of real estate because there's profit in it and you're going to run it, not only do you have a syndication, but we probably have a security. So that really is the question. How do you put together a group and not make it a security? Very difficult, very difficult. So if it's not member managed, then it's manager managed, and welcome to the security world. And the security world has a couple big chunks in it. One chunk is over here where you go to the SEC and you get permission to sell your stuff. And no one wants to do that. Some of you may have heard of Grant Cardone. Grant Cardone came to my last firm and wanted us to draft a Regulation A offering for him. A Regulation A offering is not really it's not a big public offering, it's a small public offering, but in that offering, he could stand in front of, and I've seen him, 12,000 people and pitch his offering. People walking up and down the aisles handing out PPMs. There's only one way you can do that with non-accredited investors, and it's Regulation A. And so he did that, and he raised a lot of money, and that's fine. But that's 6 months, $200,000. It's a big issue. That's nothing we want to do. But that was a big chunk. Go to the SEC, get approval, and raise money. But we raised more money is raised over here than in the SEC. This is where the $1.8 trillion is raised in offerings that are exempt from going to the SEC. And what you and your listeners are going to do is they're going to look at Regulation D. They've all heard of Regulation D, I'm sure. And that's where 90% of the 1.8 trillion is raised. Not all real estate for sure, maybe only 70, 80 billion in real estate in that 12-month period of time. But that's where the private placement is. This is where small businesses go to raise their money. I've put together offerings for racehorses, for patents, for medical equipment, for schools, for education schools, all sorts of things other than just real estate, although primarily real estate. So this Regulation D is where you want to be. And in Regulation D, the issue is it started out with rich and smart people don't need protection. So if you don't advertise, you can do a Regulation D offering and take all the rich and smart people you want because they can read the books, they can ask questions, they don't need protection. And so the rich and smart people are accredited. And accredited investors have a net worth of $1 million and or annual income of $200,000 if they file their own tax return, or $300,000 if they're married filing jointly. That's the accredited investor. And so in Reg D, you can have as many accredited investors as you want. And the question is, can you take anyone who isn't accredited? And in accredited investors, we've got a few things that are going on. As of December 8th, they kind of changed the definition of accredited investor. They said that people who have securities licenses, who sell securities for a living, are accredited regardless of their net worth. They came along and talked about a spousal equivalency. There are all sorts of households in this country where people live together, but they're not married. So the married definition of $300,000 of income doesn't work. So they said, okay, if you're living in that type of a household, we'll let you combine income, combine net worth to qualify as accredited investors. Family offices. The problem with family offices is they have a lot of people, and we don't know who's accredited and who isn't accredited. So they just decided that, hey, if the family office has $5 million of assets, it's accredited. And then certain employees of the offeree who have important jobs are accredited. So that all really doesn't start yet. That doesn't start until September 8th. Let's see if there's a question here. Karen says it's hard to read the slides. I understand. I don't know why I can't get, Karen, I can't get myself into spotlight mode, because then my screen would fill up the whole page and Stefan would be over here. We need to admit someone else. We need to admit someone with the camera. Henrik, can you turn on your camera? Okay, let's see if that works, because you're the third. That doesn't. Is this working? That doesn't work either. Okay. That's even worse, isn't it? Because now we're divided into three.
Well,
all right. Yes.
Yeah. What are you trying to do? Sorry. Because we see your full screen in the first place, but then let's say if he does start his camera, then then it becomes full screen potentially at some point.
Well, yes, because there's supposed to be something that says spotlight view, and I would take up the whole thing, except you'd be up in the corner. So that isn't working. So can you turn your camera off, Henrik?
Let me do that. Sure.
Okay. No, there. What's that?
Eugene, I can see the full screen. What I did was I clicked on the rectangle at the top right corner of the Zoom screen.
Where it says view?
So it says enter full screen.
Oh, okay. That's on your side, right? That's on your side. It's not my side. Okay.
Right. So
you went up to where it says view and it says enter full screen?
Yeah, there's a rectangular icon. I clicked on that.
Yep. Okay. It doesn't have the word view on it? Okay, just do the rectangular screen. That's fine. And now I'm the only thing you can see, right?
Yeah.
Okay, so if that works, then people will be able to read that a little more carefully, and that'll be good. So one question.
I think what also works is if you click, if you see the full gallery view, just click on Eugene's little square and then go on to the right where there's those three white dots on the blue field, and then click on pin video, and then it will just show your screen. So your background TV screen will be much larger for everyone in the audience.
Okay. Well, one of the things I'll do is I'll email Stefan a set of these slides. Okay. And then he can distribute it.
Actually, I'm sorry to interrupt. On my end, actually, I see it perfectly. Like it's, like it's well readable, etc. At least.
Okay. Well, anyhow, so we've got this new change in the accredited investor definition. We've got Henrik asked this question. What securities license would theoretically qualify? Yes, Series 7, 65, and 82. Are the three licenses that they grandfathered in. Another question, can a group of individuals form an LLC and then collectively put in to a deal accepting non-accredited investors? Yes, they can. Except for the word non-accredited. It probably have to be sophisticated investors. You could form a group yourself and then go invest in someone else's offering. I call that a fund of funds. I have a company who comes to me every year. They raise $5 million and they invest in 5 $1 million offerings where none of their people could get in individually, but collectively they could all get in and they buy $1 million share. So that happens.
What about like the Series 79? Would that be?
Well, I didn't type that in, did I?
No.
So there's only 3 of them.
It's like it's very close to the Series 7. Okay.
Yeah, there's only 3, and Series 22 or 39, none of those things qualify. Just 7, 65, and 82. If that is. If you don't have one of those, that's it. So that's going to be December 8th. That's going to be cool. And then what is that going to mean? Well, it's going to mean we're going to have about 16 million households that are accredited. So that's good. But how do you get to those people? How do you get to the accredited investors? Well, you get there through part of Regulation D. When I was syndicating, Regulation D had a rule called Rule 506. And Rule 506 is just what this said right here. I could raise as much money as I wanted. I could raise it from as many accredited investors as I'd like. All the investor had to do was check a box that they were accredited. And that's because I knew them. And I would have known if they were not telling the truth, because I knew them well enough that I had a pre-existing relationship with them. And I could take in 35 sophisticated investors who weren't accredited, but that was for the purposes of opening up 506. This was 1981 that the sophisticated investors were allowed to invest. Prior to that, it was only accredited investors. I need to do a PPM because if there's one sophisticated investor, I have to write the documents and tell people the story and give them an operating agreement. And no advertising or solicitation. So here's how that affected me. I could raise as much money from as many accredited investors as I could find, but I couldn't advertise to find them. And they couldn't find me, okay, because I wasn't anywhere on social media or anything because I couldn't advertise. So I was limited in the amount of money I could raise to the number of people I could find, and those people out there, all those accredited investor households couldn't find me. So in 2012, the Jobs Act came along and Congress said, you know, let's promote capital formation. So here comes Rule 506. They said, 506C, they said, we'll just leave this the way it was, we'll call it B, and we'll come over here and we'll carve out a new one and we'll call it C. And here's what you can do, Gene. You can find all the accredited investors you want by advertising. You can raise all the money you want. And because you're advertising, they can find you. But because you don't know them, you're going to have to take some third-party steps to see that they are accredited. And the rule is you have to make steps to be reasonably assured that an investor is accredited. I can advertise to anyone, but I can only take accredited investors, and I don't know them. So I have to do some sort of a third-party verification. No sophisticated investors at all because we're taking in people we don't know. That's too risky for those investors. Probably need a PPM, and advertising and solicitation is allowed. Now that's been going on since 2012, okay? Of the 1.8 trillion I talked about earlier, the last survey said 1.4 trillion comes here, and only about 300 billion comes here. So this is still the main way to raise money. And this is how you and the people who are watching are going to raise money. You're going to go out and you're going to find people that you know, and you're going to bring them into your deal. So here's the question. Chris says, what is considered solicitation under 506B? Well, actually, I can't really answer that question, but to defend yourself against a charge of solicitation, you have to have a pre-existing and substantive relationship with your investors. Pre-existing meaning before you contemplate an offering or start your offering, you have to know these people. Secondly, substantive means you know whether they're accredited, you know whether they're sophisticated, you know what their education and their training is, and you figured out, can they read the PPM? Can they understand what's going on? Do they know enough about you to know what you've done and what your background is? Substantive. And if you were charged with soliciting someone, you said, no, I have a pre-existing substantive relationship, you win that. So I guess the issue is if someone you didn't know somehow finds out from you about your offering while you have your offering and you took them in the offering, you would be considered to have solicited and advertised for those persons. That's probably a topic for another day, but that's about as quickly as I can explain this. We got to do a PPM. A PPM is everything that you need to tell the investor about the investment. Remember, the securities law says we have to make full disclosure. We have to protect the investors from fraudulent investments. So we have to put it in writing. And the PPM covers all this stuff. When I start with a client, I start with an interview and I ask all sorts of questions, probably takes an hour in the interview to find out information so that I can write the story. And the story is the PPM. I send the story to the investor, the sponsor, the client, we go through it and see if I've got it right. Then I can write the operating agreement, which is the rules of the story. The PPM really isn't any sort of a binding document. It's a disclosure document. You tell the story. The operating agreement is the binding document between the investors and the sponsor. One of the things that's in the operating agreement is waterfall. How do we distribute the money? And it can be a million different ways, but generally it's divided into two things. Money comes from operations and money comes from capital transactions. If money comes from operations of the property, you might have a preferred return. You might just have a 70-30 split. And so you pay the money there. This money is earned. This is a return on the investment because it's in the property. The property's churning away and making money, and we're sending out to the investors. This money over here is the return of capital. We refinance the property or sell the property. We get a bunch of money. The first thing we do is we give the investors their money back. And then if there is a preferred return, we might have to catch up if we haven't completed the preferred return during the operations, and then we distribute the rest of the cash. But it's very important that we keep these two buckets of money separate. If you're telling the people, I want to give you a 6% preferred return, and in 1 year you don't have quite enough, you can't reach over here into your reserve account, the money that they invested, and grab some of that and send it to them. That's fraud. You'll go to jail for that. Plus, if it's in the reserve account, because you're going to need to put new air conditioning units over the next 2 or 3 years in all the apartments, and now you don't have enough money to put the air conditioning units in, your investors are going to be upset. They're going to ask you why, and you're going to tell them you dipped in here to pay them, and that's fraudulent. Very, 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 very fraudulent. So big mistakes I think that people make. I guess I was going to answer this question later, but I've got some other questions I can answer. When you're doing an offering, it takes some time. So give yourself time to raise money. Don't take the money before you open the investment LLC bank account, and don't pay anyone a commission for raising money for you. That's all trouble. Biggest mistakes: drafting your own documents, not reading your documents, making cash distributions from reserves, and cashing out investors by finding a new investor to come in and buy them out. That's a Ponzi scheme. That'll be trouble. And here's some things that I think we could do, but I'm going to keep this slide for a little later. Stefan, let's see if we have any questions, or maybe you have questions.
Yeah, actually I do, and probably it's going to benefit the others as well. I was wondering on where you had the 506B and 506C, and on that portion for capital, for
yes,
syndicators who primarily raise money via building email lists, are they generally doing 506C? So basically
yeah.
this sort of segment is expanding, I assume, nowadays with technology, etc.
Well, yeah, because if you're building an email list, you're building a Rolodex, you're building your database on your computer and getting emails. One question is, did you have the email?
Right? For example, like people, like Michael Blank and things like that, who primarily capital raise online. I assume they would fall into.
Yeah, they'd have to be doing a 506C because he doesn't have a pre-existing relationship with all of his investors, and he certainly doesn't have a substantive relationship.
Yeah.
Okay, so that would be where you'd advertise 506C. Now, in my world, I'm going to tell you that experienced syndicators stay here because they have a lot of investors. They don't need new investors. My most prolific client in the last 6 years has done 110 of these. 110. offerings, accredited investors only. So all they have to do is check the box that they're accredited, no third party, and he's not taking new investors. So at some point in time, you get to plenty of investors. They want to invest with you and you stay right there. Some of my newer clients will come over here and would like to advertise to build their database so that someday they can go back over here. But right now you build your database, but then you have to go out and get tax returns and use something called a Verify Investor, some software, third-party company to go through the tests, and that can be time consuming.
Okay, so is there, let's say, is there a way to verify a pre-existing relationship or establish a pre-existing relationship while sort of in an online communication, let's say, assuming?
Sure, sure there is. And
like,
the seminal case there is, it was called IPO, Initial Public Offering, IPO net. And they went to the SEC and said, you know, we want to start a website. And on the first page of the website, it's going to be generic information about how to invest in public offerings. Not our offerings. We don't have an offering, just generic stories. Like we might put in there, why is investing in multifamily a good idea? Not our multifamily, not talking about our offering at all. It's talking about real estate and supply and demand and all this stuff. And after someone comes and reads all this, what we might want them to do is we might want to ask them a question. Are you interested in learning more? If you are, click here. And so they click and up pops a qualification questionnaire. The investor fills out the questionnaire and pushes the button submit. Now the questionnaire has gone back to the company. And what do they have? They have a questionnaire that's asking questions about, are you accredited? Are you sophisticated? What's your business experience? When would you like us to call you? Sign this and date it. Now we have the beginning of the relationship. We have a signature, electronic signature, and a date in our database of when this client came to us. And then IPONet said, what we'll do after that is we'll take our counselors, our salespeople, and we'll call these people and we'll talk to them about what their investment goals are and what IPOs are, and we'll educate them. And if it sounds like something they want to invest in, we'll tell them, you can invest with us, but we don't have anything available today. When we come out with a new offering, we'll call you. So they did generic advertising, not connected with the current offering or any contemplated offering. And they had a record-keeping system where they could prove that, well, Gene Trowbridge came on November 17th, and what he bought in January wasn't on the market until December 8th. So they prove the pre-existing relationship, and hopefully they have enough information because of their dialogue with the client to really prove that it's substantive. There's no bright line for substantive. Pre-existing, there's clearly a bright line. When did you meet the person? Did you have an offering on the street at that time? Don't sell them that offering. That's advertising. Then after that, another company called Lamp Technology came out and said, I like what IPO is doing, and the SEC said that was all fine. But we only have one offering. So we're going to do everything IPONet did, but when the person said they'd like to invest, we're going to tell them there's a 30-day cooling off period. And we'll talk to them during those 30 days, and when the 30 days is over, we'll go back to them and see if they want to invest. I hate using that example because now everyone on this podcast think there's a 30-day wait. No, there was for Lamp Technology, and Lamp Technology got a letter from the SEC that said, if you do what you say you're going to do in those 30 days between your relationship and the investor, you'll be fine. If you never talk to them again, until 30 days is over, you haven't done anything about establishing a substantive relationship. So those are the two major no action letters that the SEC has.
Right, and for the substantive part, so what are some, so to your point, the pre-existing is pretty clear. So when you met the person and, you know, if you had an offering at the time, such as if you had a generic advertising, then that's okay. But to prove a substantive aspect of the relationship, how, let's say within those, whichever period of time after establishing the relationship, is that difficult to?
Well, the SEC says that a substantive relationship is one where the sponsor knows, number one, that the investor is either accredited or sophisticated,
Okay.
knows their prior business experience, their prior investment experience, and has given the investor an opportunity to know about the sponsor. What is the sponsor doing? What's the sponsor's track record? And all that goes together to give the sponsor a feeling where the investor can really read the offering documents and alone or with their advisors, make a decision that it's something they should invest in. And then the sponsor always has the opportunity to turn away an investor if they don't think, you know, like me, I'm 72 years old. You're going to come out with an offering that's 10 years. We're going to do all this stuff and I'm not going to sell for 10 years. Well, why would you take me in that offering? Okay. Why would you do that? You know, what's going to happen to me in the next 10 years is not going to be attractive to your offering. So you wouldn't do that. Or an offering that you can allow IRA money, an investor to invest through their IRA, and you find an investor that can make the minimum investment through their IRA, but has no more money left in their IRA, and they're 65. And now the IRS is going to come to them and tell them to take automatic withdrawals from their IRA, and you have all their money. That person's not suitable for the investment. And you learn that by going through the substantive qualification deal.
Okay. Thank you. So we have a few other questions actually, so if you guys want to speak up as well, but we have some questions on the chat already. So we have Hendrik is asking, do you know what securities licenses would theoretically qualify? So that's
right
for the new accredited funded.
Series 7, 65, and 82.
Okay. And another question, so can a group of individuals form an LLC and then collectively put into a deal accepting non-accredited investors? Any issue with that?
Sure. Yes, they can, and I talked about that in the answer, the fund to funds and the $5 million offering. Sure, you can do that, but it has to be your own offering, and then you put the money in and treat it as an investment for you and your people. Okay.
And I mean, I think you discussed already, usually the active component should be relatively evenly distributed between all of them so that there isn't a manager, etc., right? As to not qualify as a security.
Right.
Okay, and then, okay, so what is considered solicitation under 506B?
Well, we kind of went through that. I would say that if you didn't know the person when your offering started, and through some of your activities, you got to know the person, you might very well decide that don't take that person in because it might be determined that you advertise or solicitation. I mean, advertising is generally printed word, printed material, and solicitation is generally verbal type of communications.
Okay. You had a slide actually, if you can, okay, we have another question. So if every member of an LLC has a vote, what effect does that have?
What was your question? I couldn't hear you.
I'm not sure if you see the questions on the chat. So a question from Chris, if every member of an LLC has a vote, what effect does that have?
Oh, okay. Well, let's go back to this this particular slide. What I think the question is can we have a member managed LLC where everyone has an equal vote and no one is running it? No one is in charge. So they're all active. Yes, you can do that. I don't know if 100 people works and everything has to be unanimous. Every decision would have to be unanimous. So for a very small group of investors, an equal vote for each investor and a unanimous vote for every major decision would be required, and that would keep you out of the world of a security. Now, here's where I hear about this all the time. Oh my God, we're just going to do a joint venture. Okay, let's just do a joint venture. Well, what is a joint venture? It's not a legal entity that owns anything. It's an agreement between two or more people to do something. Okay, many times the joint venture people are partnerships or LLCs, and they come together to do a project. The joint venture doesn't take title. These people end up taking title. And in a joint venture, if one person has control, we'll joint venture this deal. I'll bring in 80% of the money and you bring in 20 and I'll make all the decisions. That's a security. There's no question. A joint venture can be a security just like anything else, unless the joint venture has 2 even votes, and nothing can happen unless it's a majority, it's a unanimous vote. So don't fall for that trap.
Mm-hmm. And the part where you said not to pay finder's fees for
not to pay finder's fees. We
Yeah.
said here that inside the manager is where the for sale by owner thing happens. We can sell our own securities without a license because we're issuers, and it's called an issuer exemption. But if someone outside comes to you and says, I can help you raise money, you need to pay me, those people have to be securities license people. They have to be registered brokers. If they aren't a registered securities broker, they're breaking the law. And what no one talks about this, and I see all sorts of strategies and plans about having other people come and help you raise money. If your deal goes bad and these people want to take an action, and they know that Gene down here introduced them to invest, and they knew that Gene got paid, and they know that Gene is not a securities licensed person, they can go after Gene for what's called full rescission. They can come after me to get all of their money back, plus some interest. Well, I bet you didn't pay me enough to take on that risk, right? I brought in $100,000 and you gave me $2,000, and now this investor wants me to give her $100,000 back. That doesn't sound like a very good deal. But no one explains that when they're trying to put together these schemes of other people raising money for them. No one explains to the money raiser the risk they're taking. Not that I'm strong on that or anything. Not that I have a strong opinion, but don't do that. Just don't do that. If you want Gene to raise money for you, bring me in the manager group. Mm-hmm. And give me a role in the manager group, investor relations or whatever. And then now I'm an issuer and I can go out and raise a lot of money. I can't get paid. You can never get paid unless you're a securities license. Never.
Okay, that makes sense. So what is usually the usual case where sort of capital raisers get brought into I assume into the management group, but then they get paid at, let's say, 30% share of the
Well, that's okay. You
That's okay,
in the,
that's okay.
let's say the management group is
Yeah.
going to get 25% of everything, and you bring me in and say, Gene, I'll give you half of what we get. Fine. But not for raising money. It can't be tied to the amount of money I raise, because then it's a commission. And the rule, the language is there's no transaction-based compensation. You can bring me in. I'll be your investor relations guy, and I'll share in what you get. But if I don't bring in any money, I still get my 30% or 50%. If you said you were going to raise half and I end up raising all of it, I still get just what I bargained for. No change in compensation based on how much you raise, not at all.
Interesting. And that is what actually, I mean, yeah, that's clearly the legal
Well,
way.
that's what's happening.
That's what's happening,
You
right?
and I probably know gurus out there who are standing in front of classes and teaching people how to put together these little groups to help them raise money. And some of those people have received cease and desist letters from the SEC. So don't do that.
Okay, that's clear. Yeah, makes sense.
So it's just about 4:30. Haven't your people, aren't they bored to death with us yet?
Well, so guys, if you have questions, let's get them out there, as we will soon go out over time. So if anyone wants to speak up, maybe.
Can you go back to your slide that had the biggest mistake? Can you go over that?
Oh, sure. The biggest mistakes drafting your own documents. You need an attorney to draft the documents so your entities are formed properly and your operating agreements are formed properly. You need an attorney to draft the documents to make sure you don't run afoul of the securities laws, and you need an attorney to draft your documents to keep you out of trouble.
Got it.
And I actually have people who, in the fury of raising money, oh my God, I got my documents, I've got a closing in 3 weeks, I've got to go out and raise money. They don't read their documents, and they call me and ask me questions that are in their documents, or their investors, heaven forbid, ask them questions that are in the documents, and they haven't read it, so they don't know how to ask the question. What a way to look stupid, huh? So those are the biggest mistakes.
Another question from Hendrik. So from the surveys, do you know the number of 506B and 506C offerings in 2019 or other recent years?
No, I don't. I do know that 99% of the money is raised in Regulation D. 90% is raised in 506B, and the balance is raised in 506C. I think I've got that right. Overwhelming majority. I think somewhere along the line I read the number of offerings, but and that's all public record. You could find that if you wanted to go to it. It's called Edgar, EDGAR, which is part of the SEC, and you can find out all that information.
Mm-hmm. Great. Do you guys have any other questions? I think we have a great expert here. So it's really, yeah, we can learn so much, at least I can.
Do you have any questions of me?
Personal questions? Yeah.
No, aren't you going to ask me something? Aren't you going to surprise me with some questions?
Well, I actually did myself ask a couple. Yeah, so maybe if, let's give a chance to others.
How about if I tell you the biggest mistakes I made as a syndicator?
Okay.
Would that be of some value?
That sounds like it, yeah.
Okay. And, I did it for a long time, but the biggest mistakes I did is really actually the first one on here, not having enough time to raise money. I learned over time that if I don't have 30 days from the time I get my documents to go out and bring my investors in, they feel rushed. If they feel rushed, they're going to say no. They may not even be in town if I've only given myself a week. A wedding might have come up. Something else might have come up in their life. So not having enough time to raise money was a big mistake for me. And the other one was because I was in the business of being a syndicator. I felt I needed to have a product on the street all the time. Because if I didn't have a product on the street, when an investor came and said, "What have you got now?" the investor would go and find someone else and invest with someone else. And I'm not sure I'd ever get that investor back. So I know I jumped the gun maybe on due diligence on 2 projects in my life that turned out to be trouble. And the reason they were trouble is I didn't give myself enough time to do due diligence because I thought I needed to have a product on the street. So that probably was the biggest mistake I made.
Interesting. So where you said about 27 years ago, right? Where you said about having to like the multiple K1s. And
right.
So has that improved significantly nowadays, or being a syndicate?
Oh, yes. No, there are all sorts of companies out there that provide the back office. They're called portals, and you put your investors' information in, then they'll send the offerings to the investors. The investors will invest. All the documents will be there. They'll send out your quarterly reports. You have to write them, and they'll send out your K1s after the accountant gets them finished. Yes, there's plenty of help today. And what you want to do that, you want to go to the Google Investor Management Systems. And one that'll come up is called IMS, Investor Management System, but others will come up.
Mm-hmm. So would you say being a syndicator is, let's say, would you consider coming back to being a syndicator? Or?
Oh, I've passed that.
Right.
I've passed that. And I couldn't, when I became a lawyer, I made a policy decision that I wasn't going to syndicate and I wasn't going to compete with my clients for investors or anything. I'd just do one thing and over and over and over and over.
Mm-hmm. Okay. Understood.
Can you give us some idea of a range, possibly wide range of, depending on the complexity, obviously, of what can somebody expect in terms of expenses for the documents and whatever other things that may be needed?
I can tell you what we charge, and I'm happy that you asked that question. And we're a smaller firm. We do a lot of business, and we do it well, and we do it efficiently, and we don't have a lot of overhead. One of the ways I keep my overhead down is I don't have 42 names on my letterhead. I don't have a lot of partners. I don't have a lot of staff. So we're very, very affordable. Generally, well, not generally, if you raise less than $2.5 million, our fee is $12,500. If you go from 2.5 to 10, our fee is $15,000. And that pretty much is about 80% of the business we do. If you're going from 10 to 20, we'll go up to 20,000. And if you're going to do a Reg A plus with me, where we're going to raise 50, 60, 70 million, I'll probably charge you 50 grand, which is still a bargain in that price range. But for what mostly everyone does, you could budget for $15,000 and you'd be, and it's all up front, it's all fixed fees, so you can budget for it and you'd be happy in your planning. And it takes us about 3 weeks. On your first deal, it might take 4 because you haven't seen our documents before, and we have to go through a process with you. But as we do subsequent deals, it's a little quicker. We can get our work done in about 3 weeks from the time you give us a property package, purchase and sale agreement. We can get our work done in 3 weeks, probably before you have financing.
Thanks. So you focus mainly on real estate. I guess this is real estate group.
Well, yes, I do. I would say 80% of my offerings over my life are real estate because I'm a real estate guy. I've run into some other types of offerings, that's for sure, but primarily real estate.
So if somebody was doing fintech, raising some money for fintech kind of thing, would that be very different? Or
I'm not doing cryptocurrency or anything like that. No.
not crypto, but fintech, meaning some kind of business where you're developing a website or something along those lines.
Oh, sure. Like I said, I've done things that aren't real estate in the area of educational platforms, which would be, online primarily, raise
Right.
money for like that. The securities part of it, quite honestly, doesn't really depend upon what the business is.
Right.
I gave a presentation like this earlier, well, not this week, but last week too, is this CPA conference where they do all sorts of stuff. And the message was the same. I don't care what you do, because out of the 1.8 trillion that we talked about, only 70, 80 billion in that 12-month period is real estate. Almost everything else is something else. Okay. All the securities laws do is tell you how you get money from individuals legally. They don't tell you anything about what you do with the money.
Thank you. Very helpful.
Good. I'm glad it was.
So in terms of securities laws, so is every component of them nationwide, so to say? Like, are there any state differences? Let's say.
Oh yes, there are state differences. There's no doubt about the fact that there's state differences. I'm going to go back to this one here. The intrastate rule.
Okay.
Offerings that are exempt would include offerings that are totally inside of one state, and you're just using the state rules. You're in the state as a sponsor, all the investors are in the state, and the property's in the state. So then you can do it this way, and every state has a different set of rules. We do very, very few of those, because the minute you set up something that's totally in one state, one of the investors says, well, Aunt Mary in Nevada wants to invest. And you're screwed because you can't take her. And so you'd have to throw that out and start over. So we just start here with Regulation D. Regulation D is a federal law letting you cross state lines, because you're going to have a property in one state, you're going to have investors in multiple states. And if something goes wrong, where do you go to court? Well, you go to federal court. So we need federal laws. So we do everything. I mean, what did we say? We said of the 1.8 trillion, over 90% is raised in Regulation D. That's the game.
So so to your firm, for example, basically you can have any investor located in any state investing in an out-of-state property relative to his state.
Right.
And under Regulation D.
That's right. And the states, not only is it exempt from the SEC, but Regulation D is another set of words. It preempts state control. Okay, so this is total state control. Regulation D, no state control. No state can look at your offering and decide if it's good or bad. The SEC doesn't even look at your offering and decide it's good and bad. You give them an information form and they put it in their record keeping system. What the states do is the states want to know that you've come in their state and raised money from their citizens. So there's an information form we send to the SEC called Form D. A state where we've raised money from investors would want a copy of the Form D, and a list of the names of the investors that are citizens of that state. And the reason they want that, so if someday the deal goes bad and one of those investors calls them to complain with the Form D information, they can give the investor how to get a hold of you. Because other than that, they'd never know. So it's called a state notice. We just put the state on notice that this sponsor has been in the state raising money from an investor.
Mm-hmm. So let's say, so you mentioned the attorney fee for on your side as an example for putting up a syndication, for hiring an equity attorney. But what are the filing fees, for example? Like, are there substantial filing fees, et cetera? For
Well, first of all, the state notices run about $300 for every state. So in every state where you find investors, we'll have to send them a $300 check. So that could be substantial depending upon the number of investors. The filing fees aren't so bad. There are no filing fees with the Reg D. There's the filing fee for the formation of the LLC that goes to the Secretary of State. There's a filing first year fee for the registered agent that goes to whoever the corporate registered agent is, but the most of the fees are the state notices. That's where the preponderance of the fees are.
Investors in 5 different states, that's $1,500. That's
right.
Okay.
And our fee doesn't cover that. Our fee covers just doing the work. We will front all those other fees and we'll get all the notices sent and everything done and the entities formed. And then when your deal closes, after your deal closes and you have some money, we'll send you an invoice.
When you mentioned, for example, you don't cover things like cryptocurrencies, etc. So are they in a different part of securities law and due to that, or like?
No, cryptocurrency is a security.
That's what
we just chose not to cover it.
Just specifically. Okay, understood.
Yeah.
Okay, makes sense. Mm-hmm. Okay. Okay, any other questions? All right, I think we are already over time. So with that, that was really good. Thank you, Gene. It was really helpful.
You're welcome. I'm happy to have been part of this. And let's see if I can get down to the end here so that everyone knows how to get a hold of me.
Yep.
So I want to talk about, I see this slide is out of date. I can talk about that. Trowbridge Law Group, our website. We do a couple things. We do what's called a rookie camp. And a rookie camp is for 15 people. We spend 6 hours with you, 3 hours on one day and 3 hours on a day after. And I'm not talking about rookies in real estate. I'm talking about rookies in syndication. If you've never done a syndication, you qualify to come to rookie camp. And we have 15 people, and it's a very dynamic presentation. And our next one is in December. And I think it's on the website. It's $395. I mean, when I charge by the hour, I charge, $5.50 an hour, and you'll get 6 hours of my time here and my partner Jonathan's for $395. So it's a pretty good deal. We probably have one of those a quarter. Then on our website, we have TLG Talks, where I've interviewed 16 people who are in the business world of securities. And then we play those at noon on Thursday on our YouTube channel. And then we record them and they stay on the YouTube channel. So if you go to our YouTube channel, which is Trowbridge Law, you'll get all sorts of things that we recorded and posted to YouTube over the years that are educationally based. And in our TLG Talks series, I have an interview with a lady who's a very sophisticated real estate person who would never, ever want to be a syndicator. That's an interesting talk. I've got a talk with my guy who's done over 100 deals. That's interesting. I've got a talk with a rookie, a real true rookie coming out of Atlanta who's thinking about doing their first deal, who had attended rookie camp. That's an interesting talk. And then almost everyone else is in the, some of the people you might know, Del Walmsley from Lifestyles, Brad Sumrock. In fact, we just played Brad's last Thursday. That's the newest one we have up there. So we have a lot of education at our website, and I invite you to go there and take advantage of it. All right, Stefan, I got to go. I got a 5 o'clock important meeting with my lady.
Awesome.
My lady and I are going to go out to dinner.
Great. Enjoy. And yeah, thanks so much, really, again. That was really, really good. It's so helpful.
Okay. You're
Thank you.
welcome. Thank you, everyone.
For
Thank
joining.
you, everyone. Bye.
Bye-bye.